Welcome once again to my channel. My name is Msime Alex, and basically today we want to talk about the remedies available for the mortgagee, okay, or for the mortgagee, okay. But basically we need to first have a bit of recap where we need to understand different aspects that we watched in a previous video. But here we just have a recap, then we proceed to appreciate other things as the video is intended. We need to know who is a mortgagee, who is a mortgagee. We need to know the definition of a mortgage. We need to know different provisions that provides for different things. But basically, when you look at for purposes of a definition, you need to look at Section 1 of the Mortgage Act. You need to also look at the case of Santler versus Weird. It's a case of 1899, volume 2, Chancery at page 479. And basically here, it will the decision will tell you that a mortgage is the conveyance of land or interest in the property for purposes of securing a loan. Okay, that is a definition in the case of Santry versus Weird. Look at it, you will appreciate it. But for Section 1 of the Mortgage Act defines it differently. It says that mortgage includes a charge, includes a lien on the land or interest in the property for purposes of securing a loan. Look at it and appreciate it very, very well. Who is a mortgagee and who is a mortgagee? A mortgagee is the person who gives out the land or gives out the property or gives out the interest in the property for purposes of securing a loan. A person who conveys his interest in the property for purposes of securing a loan. That is what we call, or that is the person we call a mortgagee. Then a mortgagee is that person who, the one in the local sense, I will call him the person who has money. The person who is going to receive a title and give out money or gives out a loan, or the person that will create a charge on the other person's title or land. Okay, look at section 1 of the Mortgage Act. You will appreciate different definitions of these different persons. Let's now appreciate, of course, for purposes of how to create a mortgage, different types of mortgages, there is a video on this channel. Please watch it and it will give you the insight of how a mortgage is created. There are many videos on different topics under the law. Watch out and you will appreciate these concepts the more. Of course, let's now delve so much into what we call remedies available in case of default of the mortgage agreement. But of course, before we delve into different remedies, you need to know that it is important to appreciate that a mortgage only passes as security. Therefore, there is always the right to redeem the property. Okay, that is important. There is always a right to redeem the property, and that is provided for under Section 7, subsection 1 of the Mortgage Act. Find it out and appreciate it very well. You can also find out, Yuri gave us has many decisions to that effect. Always visit Yuri. It will always guide you on different jurisprudences that have been put out by different courts to that effect. Okay, let's now appreciate different remedies. For purposes of remedies, I will interest you in section 19 of the Mortgage Act. It is the one that provides for all the remedies available for the mortgagee. I told you a mortgagee is the person who receives the mortgage. A person, okay? Then it provides that when a mortgagee or where the mortgagee is in default and does not comply with the notice served on him or her under Section 18. When you look at Section 18, it provides that a mortgagor must be served with a notice in case there is the time for payment has elapsed. There is that notice that is served on him. Okay. So, and Section 19 is saying when the mortgagor does not comply or does not respect the notice served on him under Section 18, then the mortgagee has the following remedies. Okay, that is important. And number one, there is what we call, it says that the remedies are available here. One, the mortgagee may require a mortgagor to pay all the money owing on the mortgage. Okay? It may also require a mortgagee to appoint. It may also require a mortgagee to appoint the receiver. Okay? It may also require the mortgagee to lease out the property. Okay? It may require the mortgagee to lease out the property. Or he may re-enter or take into possession of the mortgaged land. Okay? Or he actually may have a right to sell the property. Right? Look at Section 19. It will actually guide you on those basics. Okay? Then let's now appreciate, when you look at Section 20, it also brings it out very well. The mortgagee's action for money secured by a mortgage. Okay? That is what is provided for under Section 20. What action should this person take in order to secure the money that he had received or given out when he created a mortgage? And they are saying that a mortgagor may sue for the money secured by the mortgage only on the following cases. Only on the following cases. Number one, where the mortgage did provide that if there is a default, okay, if there is a default, the mortgagor, by the mortgagor, okay, then the money secured by the mortgage becomes payable and in full actually. Okay, where the instrument provides, as I mentioned, where there is a default and the instrument provided that the money secured by a mortgage, actually at that time that money will become payable even when the time lapses. Okay. The other circumstance is that where the surety has agreed to be personally liable. Okay. Then there you can also the mortgagee can also make an action to secure the money. Or where the mortgage is deprived of the whole or part of his or her security, then there an action also can arise. Okay. Then now important, the best part is now who can be appointed as the receiver. What are the powers of the receiver? How is the receiver remunerated? And what are the duties of the receiver? Please appreciate Section 21 of the Mortgage Act. It brings it out very well. The powers, appointment, and duties. And basically, the remuneration. Are these people working for nothing? Or they are paid? So what is the law that governs them? Okay? So it is also an implied condition on every mortgage that a mortgagee has the power to appoint the receiver of the income from the mortgaged land. Please note, it is an implied condition. It's an implied term that actually under every mortgage agreement that the mortgagee has the right to appoint the receiver. The purpose of the receiver, we shall appreciate it very, very well. And you need to know that before the appointment of the receiver, the mortgagee shall serve a notice to the mortgagor. Okay? Shall serve the notice to the mortgagee and shall not proceed until the 15 working days have lapsed from the date of service of notice. Okay? So, of course, we are basically saying that before you appoint the receiver, you have to notify the mortgagor that, please, I'm going to appoint the receiver for these reasons and these reasons. One, you've defaulted. Two, my property should be making money. Okay, so you have to notify him, and you cannot appoint the receiver until 15 working days have lapsed. Okay, that is very, very important. And of course, the appointment of the receiver must be in writing. The law provides that it must be in writing. We are still looking at the appointment. The appointment must be in writing, okay? And in other cases, the mortgagee may apply to court for the appointment of the receiver. Okay? May apply to court for the appointment of the receiver. Of course, the receiver, it's not guaranteed. The receiver can be removed at any point. Okay? So, yes, you are appointed as a receiver, but at any point in time, the mortgagee can say, no, you are no longer working together. Okay? So, he or she can remove or dismiss you. Of course, dismissal, usually it is accompanied by a notice. These things are very strict. You must give notice to a person, notifying him that, please, at any point in time, we are dismissing you, of course, depending on the circumstances, okay? And now the basic part is that what are the duties of the receiver? Duties of the receiver, one, is to ensure that the property is cared. The duty of the receiver is to ensure that if the property can be rented, then you rent it out to keep receiving money from that property. Let's say it's a building, it's land. You keep receiving money from the tenants. Those are the roles of the receiver. The receiver is also to ensure that different repairs are made on the property. The receiver is to ensure that the property is protected. Okay? The property is protected. Then for purposes of remuneration, the remuneration is always deducted from the little money that is received, or little or much money received from the property. Okay? That is very, very important. Duties, appointment, and remuneration is covered. Let's now look at powers of a mortgagee to take possession of the mortgaged land. Do you think the mortgagee has power to take over the land? Oh, okay, that is important. Remember, this person has defaulted. The mortgagor has failed or has refused to pay in any circumstance. Do you think he can, the mortgagee can take over the property, and under what circumstances can this person take over the property? Okay, that is very, very important for us to appreciate. And of course, I will interest you in section 23 of Mortgage Act. It's the one that provides for the powers of the mortgagee to take over the property or the mortgaged land. And when you look at subsection 1, it brings it out very well that a mortgagee may, after the end of the period specified in section 18, you remember section 18 talks about the notice, where you notify the mortgagor of that period and the circumstances relating to the default. So when that period lapses, then the mortgagor may make a notice, of course. Of course, the period mentioned under section 18 contained in that notice, the notice contained the period, okay? And when that period lapses, okay, you have to also make another notice notifying him that you're going to take over the property, okay? You're going to take over the mortgaged property or the mortgaged land or the mortgaged house, like that. that notice must be not less than 5 working days. That's basically a week, okay? And the notice must indicate the intention why you're taking over or why you're reoccupying the stated property or the mortgaged property. It must, of course, the possession must also be, the notice is basically to notify him that you're taking into possession of the mortgaged property due to default. Default is the reason, okay? That is the basic importance of section 23 subsection 1. You have the right to take over the whole property or part of the property, okay? And you need to know that the mortgagee may exercise the power of entry into possession in the land by 1, entering into and taking physical possession. That is the circumstance number 1. Entering and taking into physical possession. 2, asserting the management and control over the said land. Okay, that is circumstance number 2. Number 3, or having a court order. Of course, when you have a court order, it grants you the powers to enter the land. Okay, that is very, very important. 1, having physical possession or physical entry. 2, asserting control over the said property. And number 3 is having a court order allowing you to enter. You may not make physical entry or not asserting control, but you have the court order. Please appreciate section 23. It brings it out very, very well. And of course, the mortgagee shall be regarded as being in possession of the property on which he or she enters into possession in accordance with section 2 subsection 1, and of course this is subsection 2 of this section, okay? That means all the rights and the dates, the date on which the possession, the re-entries takes effect is in accordance with section 23 subsection 2, A, B, A and C. Of course, look at it and appreciate it the more. There is also what we call withdrawal of a mortgagee from possession. What does it mean? And under what circumstances can a mortgagee be removed from possession? Okay, we have to also appreciate it. Please look at section 24. It brings it out very, very well. And it is to the effect that a mortgagee, I'm reading verbatim, that a mortgagee shall withdraw from possession of the mortgaged property where a court makes an order directing a mortgagee to withdraw. Okay? It means, yes, you have taken possession under section 23, but now 24 is saying that there is also a circumstance where court can make an order that you withdraw from possession. All right? Court is saying that, the law is saying that, yes, you have possession, but there is also a situation where we shall say, no, leave this property. And the situation number 1 is court making an order that you withdraw. And number 2 is where the mortgagee appoints the receiver. Where the mortgagee appoints the receiver under section 21, it does not necessarily need the mortgagee to take possession. You already have the receiver. Why would you now go to take over the possession? Okay, that's what. Of course, it's your right to take possession, but still you can withdraw from possession since you have the receiver. Okay, that's very good. Then, of course, the default, which was the cause of entry, has been ratified. When you took possession of the land, but the default is now cleared, then you can do away with possession. Remember, this was not your property. You had just acquired it as a security, but you have now taken over the land. okay? Or you have now taken over the property or the house or whatever. When the loan is paid, then there is what we call exercise of redemption. Exercise of redemption comes in to tell us that since I've cleared my loan, since I've cleared the money, now I have the right to take over the property, because the property under Section 7 only passed as a security, not as an interest. It did not pass any interest in that property. Okay, of course, you can also withdraw from possession when the mortgagor becomes entitled to a discharge of a mortgage under Section 13. Section 13 provides for how to discharge a mortgage. Okay, under any circumstance, please take time and appreciate Section 13 on how to discharge a mortgage. Okay, then under this section still 24, they are saying that you will withdraw from possession if the mortgagor becomes entitled to discharge the mortgage. All right, that is very, very important that you need to appreciate. There is also what we call, of course, still under remedies, there's also what we call power to sell the mortgage. Power to sell the mortgaged property. Under what circumstances can a person be allowed, can the mortgagee be allowed to sell the mortgaged property? Yes, I gave you the house as a security, you gave me a loan, but here now, do you have the right to sell this property? And under what circumstances can you sell this property? Okay, that's what Section 25 of the Mortgage Act comes in to tell us. Number one, you need to appreciate that where a mortgagor is in default of his or her obligations under the mortgage agreement, okay, and remains in default at the expiry of the time provided for ratification of that default in the served notice, you understand? Then the mortgagee may have the right to sell that property. Of course, even the sale must be accompanied by a notice in practice. Okay? You don't just jump from nowhere and sell the mortgage property. Okay? Then, of course, you need to know that before exercising that power of selling, okay, the mortgagee shall serve, as I mentioned, must serve a notice. The law provides that you must serve a notice. And that notice must prescribe the reason and must complete everything. Must show that you breached an agreement. Must show that time frame within which you have defaulted. Okay? So take time and read it. You read section 25. It brings it out very well. The situation under which a person is entitled to sell the mortgaged property. The notice must be within 21 days. Therefore, if you intend to sell the mortgaged property, you have to serve a notice. Then after 21 days, there you can resell the property. Okay? That is very, very good. There is also what we call a duty. What duty? Do you have a duty? Yes, you can sell. The law is saying you can sell. But what's the duty of exercising the power to sell? Please appreciate section 26. Look at the powers to sell under court order, then foreclosure, the protection of the purchaser. We shall also actually have another video regarding protection of the purchaser. How is the purchaser of this property protected? Okay, we shall have time and appreciate this. I wish to thank you so much, and please, I encourage you to subscribe. I encourage you to share with friends. I encourage you to like and share. For purposes of mortgage, please, I still emphasize, appreciate the Mortgage Act. For purposes of getting decisions, different judicial decisions, please reach out to Yuri. Yuri has many cases. Okay? And in case you need any case regarding this, please hit the comment section and specify basically where you need. I encourage you to always comment where you need clarification, where you feel you've not understood. Please ask a question. The comment section is always open for you. Take time and ask.